everyone. And we do record these, so everybody will be able to get them. So welcome, Judge McCain, and Judge Parker, Judge Gonzalez. So I think since we're starting with some basics, some intros, and maybe I'll get going so that we have the bulk of the time for the discussion and presentation. So welcome everyone to this month's National Judicial Network on Human Trafficking and Immigration and State Courts. We're going to be talking about the T visa regulations and how they provide helpful guidance to judges. Next slide. I'm Leslie Orloff, and I am the Director of National Immigrant Women's Advocacy Project, American University Washington College of Law. And I'm happy on behalf of NJN and SGI to welcome you all today. Veronica?
Veronica Stronson. I'm a clinical professor of law at Michigan State University College of Law. Thanks.
And good afternoon, everybody. I'm Susan Briel. I'm a judge in the San Francisco Superior Court. I've been a judge for a little over 23 years. I now have a dependency assignment, and I handle all U visa certifications for our civil division of the court. I will be handling all T visa certification requests, and we do expect to have a number of them over the next few years. I'm so pleased to be here.
Thank you. And next slide. Just wanted to let everybody know that we're up to 382 members from 39 states, and you can see that we have very broad representation and kind of where we have people from and where we don't. But we're excited that we're continuing to grow with each month. Our upcoming sessions these are the dates that they're scheduled for. There's going to be the topic on the summer webinar will be missing and murdered Indigenous women and other persons as well. And then we've begun to narrow down topics for the fall, and it looks like we don't have which topic is which date yet, but we're going to be including U visas and ethical issues, another presentation on adoption from USCIS, and a session where we're going to talk about how to use protection orders creatively to address, the needs of survivors who have come from different cultural backgrounds, different immigration status backgrounds, different religious backgrounds, and to use them creatively around those types of issues. Next slide, please.
So our learning objectives for today is to help you know why identifying survivors of trafficking will be helpful to both victim and child in cases that come before you. We want to make sure you comply with federal requirements to report immigrant children who may have been trafficked. We want to help you figure out how to sign T visa certification requests and to know what information you need and the steps that you need to take. We want you to understand why you may be seeing a lot more T visa certification requests in the future. And finally, we want to help you to link the litigants, the parties, the children who come before you to immigration programs with expertise servicing trafficking victims. And we're going to start now with state court judges' roles.
Next slide.
In cases involving immigrant victims of human trafficking. Leslie?
Yep. So the first thing we want to start out with is kind of reminding everyone, and we will put in the links with these materials that we send out after this peer-to-peer session, a link to the webinar we did with the Office on Trafficking in Persons, that talks in a lot more detail about this requirement. But basically, federal law, it's the Trafficking Victims Protection Act of 2008, requires that all state and federal agencies identify under 18-year-old immigrant children who may be victims of sex or labor trafficking. And if you identify someone in your courts, for example, in a case before you, who may have been a victim of sex or labor trafficking, There's a federal requirement as a government agency, state or federal, to refer the child's case to the Office on Trafficking in Persons within 24 hours. And the goal there, and so as judges, you're probably not going to be the ones to pick up the phone and make the referral, but you can order somebody to, right? You can, there's probably a foster parent or somebody that works for Child Protective Services, or the goal is that you take steps to make sure that the child gets the referral. And then what happens is the Office on Trafficking in Persons will actually do their own investigation in the case and determine whether they believe the child is a victim of human trafficking. And if they do, they will assign a caseworker, facilitate access to public benefits for that child. So it's a really, really important thing, and it is a federal requirement, and they take referrals even if they're after 24 hours. So the 24 hours isn't what you should be focusing on, it's the fact of the referral. And that when children are referred, they get, and if HHS determines that they're a trafficking victim, they'll get something called a child eligibility letter, which gives them access to federal public benefits and services at no cost to the state, that they have, like, if they're going to, then they don't have to apply for immigration relief to get those benefits. They can get them while they're in the process of being connected with a program that might ultimately help them file for immigration relief. And that that trafficking victims who begin the process of applying for immigration relief also get adults, if they're adults, they get adult certification letters from HHS that gives them public benefits access. Next slide, please. So Judge Briel, what else could judges do in cases involving human trafficking victims?
Well, judges can and should fill out the form for a T visa certification request if they're able to do so. But in order to sign the T visa certification, we judges need to make certain findings and ask important questions to the parties who come before us. We need to ask them, you know, what happened? How did it happen? How did you feel when it happened? Certainly identify survivors who may be victims of human trafficking. And if it's a child, refer the social worker or order the social worker to report the incident to the Office of Trafficking of Persons, the way we refer our social workers or our probation officers to report to the National Center of Missing and Exploited Children, sometimes every day, children who are missing. If children are trafficked, now we need our right arm of probation or the social worker or whoever is in that role in court to do those reports and order them to do those reports. We need to make any credible findings on the record, findings of fact, because it's going to be very helpful when we fill out the form and when a victim seeks U visa certification. We need to ensure that we protect the discovery rules and also the confidentiality rules under the Violence Against Women Act, which apply to T visas just as they apply to U visas. And certainly we need as judges to issue court orders to protect survivors who come before us from further immigration-related abuse from the perpetrator.
So today, Veronica is going to dig into this a bit more deeply, but what's important to understand is we're going to talk, this whole conversation today is going to be highlighting how the new regulations issued by the Department of Homeland Security fill in some of the gaps and the blind spots and the questions that we all had about what some of the definitions of human trafficking are, and that provide information that will be very useful to courts in both identifying trafficking, but also in signing certifications, etc. Over to you, Veronica.
Thank you, Leslie. So as Leslie said, we now have new regulations that are going to take effect at the end of August. So we still have time to learn the new definitions and the new changes that these regulations provide. And I have to say that I am very pleased because it's very pro-victim. And as all of us know, all of us in this room know, that traffickers use force, fraud, or coercion to subject victims to engage in commercial sex or forced labor. And we have new definitions and also new things that are going to help us identify victims, particularly children. Next slide, please. So we have the commercial sex expanded explanation now, and people usually say, well, I'll know it when I see it. But one of the things that is important is that now DHS, the Department of Homeland Security, has explained that anything of value, that phrase, anything of value, doesn't really mean money, right? It can be that I'm going to protect you, I'm going to give you a bed to sleep at night, I'm going to help you with your immigration papers, I'm going to help you get a job, right? Like anything like that, the government is considering anything of value, right? And so that is important because we have people who say, no, but you didn't get anything, you didn't get any money. Well, but he kept me in his house and he fed me, right? And so that's something that the government is going to be looking at saying, this is something of value to this person who received. Next. So a couple of new changes. So you have this graphic here with labor trafficking, the process, the act, the means, the purpose. But we have, next slide, please. We have, oh, this is Leslie. So it is important, right, for us to be looking at what do they mean when we are talking about labor trafficking.
Can you go back
so
a slide?
I'll give it to Leslie for the updated involuntary servitude slide.
Yeah, so before I get into that, I want to be sure that we put these slides, these are the standard definitions, the federal law definitions of labor trafficking and sex trafficking, and they all need a process, a means, and an end. And one of these ends in the labor trafficking context is involuntary servitude. And there have been a lot of questions about, well, what does that mean and what does it look like? So one of the new things that has happened is that in the new regs, next slide, please, the Department of Homeland Security has given us a lot more definition on involuntary servitude. And so as under the new regs, it's a condition of servitude that is induced by a means, by means of any scheme, plan, or pattern intended to cause the person who it's used against to believe that if they didn't enter into or continue in such a condition of servitude, that there would be that either that person or another person would suffer serious harm or physical restraint. And so it can, and it can also include a condition of servitude that's induced by abuse or threatened legal process. And as judges, you can understand that findings about, can you go back one second? That findings of the scheme or the plan or a pattern, or findings of abusive legal process, findings of civil serious harm could be super helpful in this. So let's, next slide, please. And so a condition of servitude is when they're forced to work by their trafficker. And these are pretty much quotes. I didn't put the quote marks because I divided it up a little bit, but conditions of servitude in which the victim is forced to work for the trafficker by use of physical restraint, physical injury, or use or threat or use of the law or legal process. So I'm going to get you deported. I'm going to take your immigration papers. I'm going to keep your passport, are some of the legal process ways. And that it also includes placing the victim in fear of, so that they may not have actually been in physical restraint, but they believed they would be, or be physically harmed or injured or coerced, or, with them using a threat of some kind of legal coercion, is enough. So as well. Next slide, please. So there are new definitions for serious. So we're now going to go into the definitions of serious harm and abuse or threatened abuse of the legal process, because both definitions are important not only to involuntary servitude, but also play into what is coercion. So, yeah. And so serious harm under the new regulations means any harm, physical or non-physical, including psychological, financial, or reputational harm that is sufficiently serious under all the surrounding circumstances. So they look at the totality of the circumstances to compel a reasonable person of the same background and in the same circumstances. So it's not this generic reasonable person standard. It's a person like this person, right? To perform or continue performing labor or services to avoid incurring the harm. So this is the definition, and it's, I think, super helpful. And I can imagine there are a lot of things that you would be seeing in your state court cases that could establish elements of this.
So I'm wondering if anyone in our audience has had a family violence case or a dependency case with involuntary servitude fact patterns. I know we have 15 participants now, and we'll have a lot more who will see this. Anyone want to shout out some case that they've had?
For example.
No? Examples? I mean, I can share that we had an interesting case in dependency where a husband brought his wife and child to the US, and he basically used her as a domestic servant. He locked her in the cellar at night, made her sleep basically in the basement. And during the day, he forced her to just clean the house, do whatever tasks he had for her, and forced her to have sex with him. And it was clear after a while that she was a victim of labor trafficking, and that certainly trafficking can occur right alongside intimate partner violence. And so this was both, a sexual violence and trafficking case that really fit the definition as Leslie and Veronica just went over with you.
I think we have Judge Parker.
Oh, I can't see the people, but is Judge Parker?
Yeah.
Sorry, my technology.
There we go.
I had a case where the person kept getting picked up for shoplifting, and they were shoplifting odd things. And when they came to court, it was known that, or discovered that they were shoplifting to support the abuser's family. They were, getting groceries or baby clothes or, other things to support him, his lifestyle, and the family. And if she didn't acquiesce, then she would get, beaten, raped, etc. And I'm glad that I'm hearing about this T visa, because that's something that she would have absolutely been eligible for. This was a few years back.
Mm-hmm. Right. No, it's a good example of what I think now the regulations are making clear would be covered. And a good example of the kind of facts you could find in a case that would establish that she could use in applying for a T visa.
Absolutely.
Next slide.
So I think that we've gone over examples that do fit the definition in domestic violence or family law related cases, so we can go on.
Yeah, so I'll give you, what's really great is that next slide, please, is that the policy manual that DHS, so the two sources of law, I guess you could say, that the Department of Homeland Security has issued, or U.S. Citizenship and Immigration Services issued, are both the regulations, and then there's a complementary policy manual. And the policy manual basically talks about involuntary servitude in a domestic violence relationship as places where the traffickers controlling their liberty, creating conditions of servitude. There's an expectation that the victim life fulfills the trafficker's orders. So for example, in Judge Parker's case, if that victim didn't go do the shoplifting, there were sanctions, right? She was abused, she was raped. And so that the demand of the trafficker to prefer, and that this happens also in the labor context. And that they recognize that it's unreasonable level of work, unreasonable level of hours, constant availability for labor without regardless to health or energy, lack of control over their own wages, despite the labor, being under the trafficker's demands. And they even recognize that imposition of unequal living arrangements, like Judge Brill was talking about, living in the basement, being ordered to work all the time, those things could all contribute as factual parts of a finding of domestic servitude within involuntary servitude within a domestic violence relationship. Next slide.
So I think this is me.
Yeah.
So one of these things, and I know Leslie covered this a little bit, and I'm also thinking about the comment that Judge Parker made about the use or threatened use of law, legal process, administrative, civil, or criminal, right? When you have someone forcing another party to engage in activity that they know is going to have criminal repercussions, for example, but the most common use that we see with the abuse or threatened abuse of the legal process is threatening with deportation. And I know Leslie covered this a little bit, or like I'm going to throw away your passport if you don't do X, right? And so that's one of the things that the government is definitely being very aware now, given that all the cases that people have been filing, right? Like how there is all this pressure on one person to engage in an activity that may be criminal, because that is part of the trafficking. And so that's very important. And I'm glad that we are doing this, because then it's giving you more ideas, right, for you to identify what's going on in your courtroom that they may determine that it's an abuse of the legal process. Next. So Judge Brill, have you gotten any abuse of legal process in your courtroom? Have you seen anything similar to what I was just discussing?
Well, I've seen it in the context of restraining order requests. The victim is just asking for this restraining order. Now the people are rather savvy and coming to the court. She's just trying to get this restraining order, judge, so she can use it to help get immigration relief. And and it might be part of a larger trafficking situation or domestic violence situation. But what I've seen often is threats of deportation. I know the National Institute of Justice has said the number one fear of all battered women is fear of deportation. And now we're seeing that the number one fear of all survivors of human trafficking is also fear of deportation. So I do see the threats in particular cases. If you report this, or if you go to the police, or if you say that I'm not letting you go to school because you're working so much in our restaurant, you'll go back to your home country and we won't help bring your parents here. So yes, I do see examples of the abuse of legal process in various cases.
Anybody else have examples, maybe from their cases they want to share?
Well, Judge Raymond has a message on the chat.
Right, fear of, right, so there, basically, this is, so she's talking about, so there are cases called, where the abuser filed immigration papers for the victim. Usually, they'll have to be a US citizen or lawful permanent resident. And the victim actually got what's called a conditional green card. They got a 2-year green card, where without domestic violence, the law is that the parties have to come back together and file a joint request for that waiver. And what you're describing is that there's a fear that the abuser won't cooperate in filing that joint request. So there's actually a remedy that is independent of that you wouldn't need a T visa for. It is called the battered spouse waiver. And so the victim who can prove that so if a court, let's say, were to make findings, issue a protection order, make findings in a domestic violence case about the domestic violence happening, the victim could go forward and get her full green card not only without the cooperation of the abuser, but without the abuser's knowledge or assistance in any way. So there is a remedy for that. And if it's something you want to know more about, or the people, the lawyers that are representing people before you might want to know more about, Veronica and I did a huge webinar with lots of materials on battered spouse waiver. I was actually involved in drafting that remedy a long time ago.
Veronica, what I'm seeing is both abuse of the legal process, threats of deportation and such, but also claims by the perpetrator of abuse of the legal process by the survivor.
Yes.
And that's where, the restraining order example came in. So actually I'm seeing both, and I expect to see a lot more.
Yeah.
Yes, I mean, even taking away the children, right?
Yes.
If you call the police, I'm the US citizen, the judge is going to give me the children because you don't have papers, right? Like just something that is going to be so horrible for the victim who doesn't really know the legal system in the United States, and who is getting most of her information from the abuser, right?
Yes,
and we see that a lot.
Or I'm the citizen, I have a passport, I'm going to take our children to India, you will never see them again.
Right.
Yeah.
Exactly.
Yeah.
And that's a real threat. I mean, that's the threats to be very wary about, because he likely has the ability to travel. Next slide, please.
Yeah. Yes. So one of the things that you're going to see with the new regs, when the new regs take effect in August, is that now we have a definition of attempted trafficking. So this is going to help a lot of people who actually did not go through the act of trafficking, but someone attempted to traffic them. That is going to be enough for us to be able to help that victim, right? Maybe the applicant hasn't done the labor or hasn't engaged in the sexual activity, right? Maybe the victim escaped. Maybe, there was a raid and everybody got arrested, and so the abuser wasn't able to traffic her, right? That is very important because we can actually make a case for attempted trafficking, and now the regulations are supportive of that. So I am very happy with that, because I have a lot of people who come and say, no, but nothing really happened. No, he didn't do this to me. No, but if we keep inquiring, I mean, obviously, you judges have the power of the bench, right, to ask more questions, but it is important to try to identify those attempted trafficking cases as well.
So how might Judge Briel, these new regulatory definitions assist state court judges?
Well, I think it's important. It's not just the victim who's going to say, well, nothing really happened. But it's also the attorneys who are going to be saying, my client didn't traffic anyone, nothing really happened. And these new regulations will greatly assist us judges in knowing that attempt itself is a crime. So for example, you might have a victim who is a massage therapist, and she goes to a massage parlor, is hired to do massages, and actually the owner exploiter wants her to engage in commercial sex acts, and she doesn't want to do that. She runs out of the place. She runs away and reports this. Well, the defense attorney might say, well, he didn't do anything at all. There was nothing that happened. But now we know that attempt itself is a crime, and as judges, the standard to sign a T visa certification request, just like use, is any credible evidence standard. And certainly when you get the information and the facts as a judge, knowing these new regulations, you now know there's a crime of attempted trafficking.
Mhm. That is sufficient for a T visa.
Absolutely.
Exactly. Great. So now we're going to talk about T visa declarations by judges and give you a little more detail about those. So next slide, just to remind everybody. So these are the T visa requirements. So they have to be a victim of severe form of human trafficking. And that's where those commercial, like the infographic charts that we showed you in the beginning, can be helpful, because they're using the federal definition of human trafficking. Or if your state trafficking definition is broader, that's the definition that would apply. The applicant has to be in the United States because of the trafficking. That doesn't mean that the trafficker brought them to the United States. They could have come in another way to the United States and ended up being trafficked, or they could have left and returned because they're part of an investigation in the US regarding trafficking, or they're getting services in the US because of the trafficking that they wouldn't be able to get in their home country. They have to be willing to make some kind of a report to a government official about the trafficking. That's a police, prosecutors, or a court. So they could be reporting it essentially to you as part of their protection order case, or their divorce case, or a criminal case, or a juvenile case.
But it can be oral. Is that correct, Leslie?
Correct. And right, Veronica? Because she's
Yes.
the immigration lawyer. Okay. And they have to be willing to respond to reasonable requests for collaboration in the detection or investigation or prosecution, and the regs actually say, or sentencing or conviction of the trafficking or trafficker. There's an exemption for under 18-year-old children, and there's an exception for adult trauma victims that we'll talk about. And they have to show hardship. There would be hardship, or it's actually severe and unusual hardship if required to return to their home country. Next slide. So the best practices is for T visa victims in their applications to include in their application a declaration signed by a judge or other government official, law enforcement, prosecutor, judge. It's the same group of authorities who can sign U visas. And the big difference here is that T visa declarations, while preferred and best practice, are not an absolute requirement to file it, which is why judges see less of these than the U visas. And the direct declaration itself provides evidence that helps the victim prove to DHS, the Department of Homeland Security, in their T visa case, that they're a victim and that they've taken steps to provide information to police, prosecutors, the courts, that leads to that's related to the detection, investigation, prosecution, conviction, or sentencing of the trafficking or the trafficker. Next slide. And these are all the different agencies, just so you know, that can sign declarations. And it's been defined further. The list of federal agencies that can sign declarations has been expanded under this new rule. And this new rule codifies the fact that being helpful in detection is enough for the declaration to be signed, which is basically any time somebody reveals to you facts of, I'm going back, Judge Parker, to your case of, the theft that's occurring because their trafficker is making them, that's sufficient in reporting that as part of information to a court. Next slide, please.
So I guess I just have a brief question for Veronica. I think that although declarations are not absolutely necessary, they're preferred. And correct me if I'm wrong, it's really much more helpful to the survivor to have a declaration. Is that correct?
Oh, absolutely, because it's going to corroborate the story, right? Oh, a judge signed this. You know, there's something here, even though it's not required in some instances, and we're going to cover that in a little bit. But yes,
Okay.
it never hurts to have one.
Okay. So why would victims seek a T visa declaration from state courts? And here's a multiple choice question. Would it be A, it may be the only justice system contact for a custody protection order, civil employment, or child welfare case, the only contact by the survivor, or B, there's no language access to police when the victim called for help, C, no prosecutor's office involvement in the case, or D, the judge observed the victim's attendance and participation in the criminal case, and that's why they're seeking this from a judge. What do you think? Those,
You can put the answers in the chat,
yes.
any that
Would it be
apply.
A, B, C, or D?
Anybody want to try? No, we didn't.
I think they're thinking.
Okay.
It's kind of like Siri and Google. They're thinking, they're processing. Judge Collins says A, B, C, and D. Judge Parker says A. Judge Raymond, all. Judge Gonzalez, all. Well, if you said A, you're correct. If you said B, you're correct. If you said C, you're correct. And if you said D, you are correct. So it's all of these things.
Great. Next slide. So you might be wondering what the T visa declaration asks you, like what the form actually asks you. It asks you to identify the types of human trafficking, labor, child sex, or sex. They ask you to describe the victimization. If, they'll want you to, like with the U visa form, to put the statutory citation of whatever crimes you detected or found, under the whatever the citations are under the state laws. You have to understand the people who adjudicate this are adjudicating them from 56 different jurisdictions with 56 different state laws of all the crimes. So it's very helpful for them to have the state laws. Dates can be exact or approximate. You want to describe the victim's involvement in the case. She came to court, she testified, she made a police report, whatever you have information about. It's very important because because the victim has to show hardship upon removal. Anything that you might see in your case regarding the risk to her of retaliation or revenge from the trafficker if she's removed from the United States, findings like that can be super important. And then they also want the names and the relationships of any family members involved in the human trafficking. They really want the government officials to identify that, so that the perpetrator can't come in and say, I should be part of her T visa when he's really the trafficker. So it's really important to identify the family relationships and who's who's a perpetrator and who's a victim and who's a child as part of that in terms of whatever your findings are. Makes it a lot easier for DHS.
I also think it's important if you have a state law of human trafficking. For instance, in California, we have 236.1 of the penal code, not to just put that state law in the form, in the declaration, but to put all the different crimes associated with it, such as false imprisonment, such as assault, such as rape, whatever else has been going on.
Right. You want to check all the boxes that apply. Absolutely. Next slide, please. I just want to say a few words on this because I'm conscious of how much time we have. That as with the U visas, so the T visas have what's called Violence Against Women Act confidentiality protection, which basically means that information about the existence of any T visa case the victim ultimately files, about actions taken in the case, and documents and information contained in the federal immigration case file are not discoverable in state court cases, certainly not in civil cases, not in family cases, And the only exception is that if a judge or a police or prosecutor does a T visa declaration, that declaration is discoverable under Brady in the criminal case, but it's the declaration and whatever cover letter somebody said requesting the declarations that's discoverable, nothing else. Any questions about that, or Judge Briel, do I need to explain about it? We have a whole webinars on VAWA confidentiality too.
But that's only after a weighing process, if that in and of itself is going to be discovered. And often there's reasons for a judge not to allow that in the trial.
Perfect. Veronica.
So we do have a couple of exemptions for the visa certification or declaration. Next slide, please. And it makes sense, right? One of them is definitely minors, and we have always had that when children who are victims of trafficking, who are under the age of 18, they don't need to have this cooperation, and they don't need to have the judge's declaration signed. Another one is trauma. When you have someone who is an adult who has suffered physical or psychological trauma, that person also is not required to submit a declaration by law enforcement or a judge. This is actually great because a lot of people don't know that trauma is an exception to doing the certification. Usually people say, well, children, right? Like, yeah, that makes sense. But when you have people who have suffered a lot of trauma before you and you're making decisions and making orders in that case, right, that's going to be important because the victim doesn't have to submit that declaration by the judge. But as Susan Briel asked before, if you have it, right, if you want to sign one, that's perfectly fine. It actually gives strength to the case, but it's not necessary when you have someone who has been traumatized due to physical or psychological damage.
Veronica, if I can jump in on this one, but I want to say that actually documenting the trauma or the age of the minor and the age of the minor in your state court orders can be really important, because whether or not the victim has a declaration, she's still, in order to get to get DHS to agree that she has no obligation to cooperate in prosecutions of the traffickers, they have to make a finding about the trauma. So I actually think it'd be better practice to sign the declaration attesting to her victimization, and then you don't have to fill out the part about the cooperation, and then but also make any findings you make about trauma in your court orders are going to be super helpful to the victim in their immigration case.
Sure, it's definitely going to make the case stronger. Absolutely. Yeah. Thank you.
So what type of court findings and orders might be helpful for a trafficking victim to prove trauma? And as Leslie just said, it's really important to document the trauma. You do it on the record in court and document the trauma in the T visa certification request. I mean, just as simple as asking the survivor who's in front of you, how did you feel? How did you feel? I was terrified. I couldn't speak. How did you feel was there a threat to kill you? Was there a threat to kill your family in your home country? Document the impact of the fear and the violence on the mental health of the survivor. All of these things can be documented, the history of exploitation, how old the survivor was, because sometimes the younger the survivor of either forced labor or forced sex trafficking, the greater proportionally is the trauma that they're suffering. So it's important to look at the mental health consequences, the physical health consequences, and to document everything about the impact, the trauma of the suffering of the survivor and the trauma that they've suffered.
right? And the next slide summarizes some of this.
Right, look at the maturity of and age of the victim, and the history of abuse is also sometimes important to look at in court and to document. And photographs, police reports can be referenced if there is a T visa certification request.
Next slide, please.
What other factual findings would be helpful to a victim to prove they were trafficked? Well, I always think it's very important to make a credibility finding. Those cannot be overturned on appeal. And I have no problem making those findings all the time and saying to a victim, I believe you. Let's see, helpful findings. Here's a list of them. Threats, physical restraint, helpful findings. List anything of value in the case. I had a young girl who said to me with an interpreter, he didn't do anything to me. I went out on the street on my own and did what he asked of me, and he gave me a new lipstick and a bed to sleep in. Well, that lipstick and a bed to lay her head on was a thing of value, as we have learned from Veronica and the new regulations, is a thing of value that can be documented. Any findings regarding a plan, a scheme, as Judge Parker said, keep sending the child out to steal is becoming kind of a pattern and scheme. Findings like in a case where a child was sent to the United States and was forced to work in a restaurant at all hours of the day and night and wasn't allowed to go to school. Findings that child didn't control his own wages, wasn't paid. And look at the harm to both the mental health and physical health of the survivor and document all the time. Those are very helpful findings for the T visa certification requests and just for the case itself.
Yeah, next slide.
Again, victim is receiving treatment for services. That's a helpful finding. Treatment that may not be available in the country of origin. And the cooperation and participation of the victim with law enforcement, prosecutors, or courts. Trauma suffered, we've talked about that. The child's age and current or future economic harm.
And age at the time of at least one incident of trafficking is really important, because that's what DHS is going to look at, or the Office of Trafficking in Persons is going to look at as well, about in terms of the child being a child when they were trafficked.
Leslie, if I may, there are a couple of comments on the chat that
Sure.
we don't want to ignore. So definitely the finding of credibility, one of the judges said is an excellent suggestion. And also another judge said the child protective records or mental health evaluations, right, can also be used when presented in court.
Right,
Those
absolutely.
are the DHS records. So I just wanted to make sure that people are engaged in this.
Absolutely. And in fact, they can be attached, like if your court rules allow, copies of those things, like copies of photographs of injuries and things, can be attached to the certification itself from the court record. That helps the victim get access to those as well. Judge Briel?
Yeah, I also just want to point out that word detect. I'm not sure it was in the old T visa certification regulations, Veronica. I don't know if
Wasn't.
I'm sure you know, but detect is important here. You don't have to have a prosecution. You don't have to have a conviction. You don't have to have a sentencing. Just like with the U visa, if a judge detects evidence of trafficking, the judge needs to note that on the record.
I think we may have Leslie to thank for that one. right? Like Leslie has absolutely been very active in pushing for these very, very good changes to the regs.
Yes, and that's new. Am I right, Leslie?
Yes, it is new. It is
So
new.
detect is really important for us judges to recognize. We need to detect detection.
Yeah, exactly. Next slide, please.
So declarations can be signed by an investigator or a prosecutor, and it can be signed when there's an investigation happening or the investigation is over. It can still be ongoing or closed or settled. The case can happen, and the T-cert request can be signed even if the trafficker hasn't been arrested or prosecuted. There is no statute of limitations on signing these T visa certification requests. That's really vital to understand. It could have happened 10 years ago, and somehow it's being brought to you now. Maybe the person, the survivor, fled and then came back, but there's no statute of limitation.
Or for example, in using the example that Judge Parker mentioned, let's say that child is coming back to the court every 6 months for status hearings because they don't, they're still in foster care or they haven't been permanently placed, or for some reason the case is still open. At a later status hearing, you could sign something even though the detection of the incident happened much earlier, or the trafficking happened much earlier.
Another thing too is that there are jurisdictions, particularly police departments, that have an internal policy where they don't want to sign anything if the case is, 2 years old, for example, right? Like they have their own policies in place. And so it is important not only to remind them that there is no statute of limitations, but you as judges may be the only ones who are there to be able to sign because the police department has said no, given their internal policy.
Exactly. Next slide. Veronica?
Oh, yeah. So family members are also included in T visa applications. So before, we used to have this rule that now has changed where the person, if the person wanted to include relatives, and that's a spouse, a child, stepchild, or a parent when the child is the victim and the child is under 21 when he's filing. So before, the relationship needed to have existed prior to filing for the relatives to be included. And now we are able to include relatives who were acquired after. So let's say I was a victim, I was single, and then I went ahead and married someone who is not my trafficker, then I'm able to include him even though I acquired that spouse after I filed my petition. So this is very, very important, or for people who marry someone who may have children from another relationship and they become your stepchildren, right? Those are people who are now able to be included in the application. Adopted children is another very good example. So the regs are very generous with family members.
Next slide.
So, Veronica, what is this new bona fide determination process?
Yeah, so as
Next slide.
you may know, we only have 5,000 visas issued every year, T visas issued every year, and we have never exhausted the 5,000 limit a year, but it has taken time for them to get processed. Not as bad as the U visas, but it still takes time. And so the government has decided that they are going to deem an application bona fide when the person has filed the application. The form is the I-914, that is the form that is used. The applicant has submitted a personal statement, and then there had been background checks performed, the fingerprinting, the biometric that gets done in every single case. And once the case is determined to be bona fide, then the government is going to allow that person, next slide please, to obtain a work permit, which is also essential for people to have economic stability. Next.
Slide.
So is it almost like a prima facie finding?
Exactly. That's what it is. But one of the things that is important is that they don't want just a bare bone, right? They want to make sure that you have at least submitted a personal declaration explaining the victimization, right? That's going to be important because sometimes people just submit the form with nothing else just because they want to get it in. That is not going to be sufficient. The government wants to be able to review the application and do a prima facie determination to make sure that eventually this person is going to be receiving that TV.
And this is,
It sounds like the bona fide determination is going to speed up the process. And so once attorneys understand this on behalf of their clients, there will be more T visa certification requests.
correct.
Yes. And
Right.
once they know that the timeline to receive that bona fide determination is short, then you'll be seeing more in your courtroom.
Yes.
Exactly, because it's going to strengthen their case and make it more likely they get a bona fide determination. Exactly. And that gives them work authorization, protection from deportation, and a referral to HHS for public benefits. So it's a really good, it gets victims the support that honestly Congress wanted them to have as early as possible in the process, much sooner than they have been.
Yes, and it protects people from fear of deportation, right? Like the
Right.
government is going to be looking at this and saying, we are not going to be removing this person from the country because this person has a valid claim
Yeah.
for as a trafficking victim. So
Next.
that is definitely going to be very helpful for our clients.
So, yeah. You want to, and so the other thing that's happened is these regulations included laying out the policies that ICE is supposed to follow when DHS knows, because somebody's filed a T visa, that this is a trafficking victim. So there are real strong removal protections in this reg. Next slide, please. We only have a minute left, so we're
So
gonna.
I just want to talk quickly about benefits, that once the T certification request is filed and approved, they can, or even before it's approved, correct me if I'm wrong, a survivor can access public benefits.
At the bona fide determination.
Yeah.
Okay, at the bona fide determination, but that's so important because it gives survivors economic stability. It gives their family economic stability. They don't have to wait for health care, for SNAP or food stamps to feed their family. But most importantly, it helps them extricate themselves from their exploiter, whether it's forced labor or forced sex. And as there have been many studies that have shown, and certainly some pivotal studies that Leslie Orloff has been involved in, they show that it's these benefits that help a survivor gain independence from abuse.
Yeah, 2 slides forward, please. And we have a chart that you can look up in your state what victims qualify for, and we can share that with you after the webinar. We're going to end on one last question that Judge Briel wanted to be sure we ask Veronica.
I do. I want to know if there's dangers of traveling abroad for children or adults eligible for the process of filing or granting a T visa. I've had a survivor in my court who wanted to go back to Honduras for a funeral. Can you talk about that?
Yes, but they are able to travel, but they should not travel before getting advance parole. Basically getting permission from the government so the government doesn't assume that the application has been abandoned. So there is a process to apply for advance parole. There is a particular form that people need to complete. And then once they get their advance parole approved, they can travel and come back without fear that their application is going to be closed. And so that's very, very important.
Is that for T bona fides or T holders or like, or do you, which one?
Even if you have, it's the T holder visa, right? Because usually they have not gotten their green card yet. And so they are not authorized to travel unless they apply for advanced parole and they get granted.
Right. And which means that somebody who's filed for a T visa has to wait until they actually get the T visa before they can apply for advanced parole.
Yes.
Somebody who's pending doesn't have the dangers of travel are much worse.
Yes.
And so we are right at the top of the hour. Next slide, please. We have lots of resources that we're, next slide, posting together with this webinar. We're going to give you a copy of the T visa regulations. There's some very good summaries from CAST, great anti-human trafficking program in California. We're going to connect you with the webinar on OTIP and probably one on benefits as well, in case you have questions about that. The benefits map, and then different kinds of other tools that we think might be useful. So I want to thank you so much for your time and joining us today, and your attention, and your participation. If you have any, the recording will be sent out to everyone. We're also going to send an evaluation at the end. So please fill it out and let us know what we can do more of. And thank you so much for taking the time and the breaks from your bench to join us for this peer-to-peer session. We really appreciate it.
Yes, thank you
Thank
so
you,
much.
everyone.
It's been a privilege.
Take care.
Thank you.
Bye.
Bye-bye. Susan, are you